Realtors, welcome to next webinar in our series. It's Fair Housing Month. It's April, and we have a very special guest, Ms. Delaine Frierson. She's the Director of Fair Housing Division, South Carolina Human Affairs Commission. Human Affairs Commission is who you make your reports to for any fair housing violations in South Carolina. Ms. Frierson has conducted housing and employment training locally and regionally. She's an adjunct faculty member at the National Fair Housing Training Academy, and she's completed certification as a housing civil rights professional through the Fair Housing Training Academy as well. She's also a member of the Housing Committee of the Greater Columbia Community Relations Council, and member of the South Carolina State Affordable Housing Study Committee and the South Carolina HousingSearch.com Advisory Board. She's a national board member of the National Association of Human Rights Workers and is a graduate of Leadership South Carolina. Ms. Frierson, thanks for speaking with us today. And this is going out to all the realtors in South Carolina. I'm going to hand over my microphone to you.
Everybody. I will be talking about what every realtor needs to know about fair housing, and I will cover some of the basic things that we find in fair housing that I think everyone needs to know. And I will go over types of discrimination, examples of discrimination, what we see most at the Human Affairs Commission. The South Carolina Human Affairs Commission is substantially equivalent to the Fair Housing Act, and we do the same thing as the federal HUD does, but except we do it on the state level. And the law states that it's illegal to discriminate against people based on 7 protected classes, and it's race, color, religion, national origin, familial status, and sex. And in South Carolina, we see mainly cases of race discrimination and discrimination based on disability. I'll give you some examples of the types of discrimination. Some could be the refusal to sell a house or to rent a house, different terms and conditions or privileges for people because of the protected class that they're in. And when I talk about protected classes, those are the classes that I mentioned earlier. And when we talk about terms and conditions, that can cover just about anything that you can think of. We see things where people feel that they are being discriminated against because they're being cited for parking in the wrong place, or because the children are making a lot of noise, or because they don't keep their place up. So terms and conditions can be just about anything that you can think of. The third one that I have highlighted, representing that housing is not available when it is available. This occurs a lot when people go to try to rent apartments. For example, if one person goes and they say, well, we don't have anything today, come back later, and then say that person was a black person, and then maybe a half hour later someone shows up, a white person or Hispanic person, and they say, yes, come on in, we have housing available. Well, that most of the times is discriminatory. Now, sometimes it may be an instance where something just became available, but most of the times it's, if we investigate it, we find out it's probably something that's discriminatory. Discriminatory advertising occurs when you place ads, and we don't see this type of blatant advertising as much as we used to. But for example, if you put an advertising up and say women only, or no blacks allowed, or no children allowed, this is discriminatory advertising, and naturally that is a violation of the law. We're talking about discriminatory advertising. Some of the things that you can do to avoid discriminatory advertising: first, describe your property and not the population. And when I say that, I mean, don't say that, this is the housing that we have for young singles or this is a housing that we have for older couples. It's a nice, quiet place where, no children, and it's, you just don't want to do that because that excludes a whole protected class. When you use terms such as a good Christian community, or this is good for single adults or mature adults, these indicate a preference. And when you indicate a preference, you advertise, and that's discriminatory. Now, most advertising is in writing, but then when you indicate a preference, then you've already said what you want and what you don't want, and that can be discriminatory. You're better off if you just talk about the amenities. We have a swimming pool, we have a clubhouse, tennis courts, something that appeals to everybody instead of something that singles out a particular group of people. And so you don't want to make that, you don't want to do that discriminatory advertising. When you do have an advertising campaign, make sure that all of your staff knows what that is and it's in writing and that they comply with the policy. Sometimes when you have staff members who aren't aware of what discriminatory advertising is, they may get you in trouble by, posting something, putting a sign out saying, here we have something for single adults or men only or women only, and they can get you in trouble. So if you have everything in writing and you make sure that your staff is aware of what it is, then that's best for you and everybody involved. Make sure, again, that you don't indicate a preference for a protected class and don't exclude a protected class. When you advertise, you don't want to put up a sign and saying, this is not a place for children, and especially like if you're dealing with college students, you don't want to exclude families with children, anyone. Just make sure that what you do for one class, you do for all, unless you have special housing that is for people aged 55 or older. But then if you do that, you would have to have certain amenities that would qualify, those people be qualified for. When you talk about advertising, also, you can make sure that the people in a protected class are not excluded by, when you put up your signs or your posters and you advertise in the newspapers, don't use everybody in, like don't use all white people, don't use all black people. You want to include, you want to have diversity. You could have people who are in wheelchairs, families with children, and so people will see these advertisements and say, well, I feel welcome. Now, when we talk about steering, this can happen a lot when you're trying to sell a house and you have people that come and they may, sometimes the people who want to buy a house may express a preference, but you as a real estate agent have to make sure that you don't steer people to a certain community. For example, you don't want to say, you may be happier in such and such a community because, there are people, people like you here in this community. You want that buyer or renter to make their own decision. For example, we had a case where a couple wanted to live in a mixed community, but the real estate agent, for some reason, felt that they might be happier, and this was a white couple, and that they wanted to live in a mixed community. The real estate agent felt that she wanted to show them all white communities, and that's what she did, and she made disparaging comments about people of a different race. So the person filed a complaint, and we investigated, and then they also found out that this real estate agent had made several comments like that to other people. And so we investigated and we conciliated that case, and she had to pay money to these people, and because of her discriminatory actions, she was only showing them neighborhoods, homes in white neighborhoods. So you don't want to do that, and you don't want to target just certain groups when you show homes. If buyers or renters ask you about the racial makeup of a neighborhood, or types of schools in that neighborhood, you can refer them to the demographics of that area, but you want to be careful that you don't say yourself, this is an all-white neighborhood, or this is an all-black neighborhood, this is a neighborhood with no children, so you might be comfortable here. Let the buyer make his or her own decision. When you do advertise in the media, don't advertise where you just have the media that caters just to one group of people, because you can get in trouble with that too. Now, you can run ads in English and another language. For example, if this is a highly Hispanic area, you can run ads in English and Spanish, but you don't want to just single out one group or just one community where you do your advertising, because people feel left out and they feel that they are being discriminated against in that area also. I think I said earlier, make sure that your pictures represent everybody. Don't just have all pictures of one group. That you have billboards and posters all over town, advertising flyers, booklets. Make sure it's diverse. Now, when we talk about renting, and this would apply mainly to renters and not people who buy, but when you talk about renters, there are no federal laws that talk about occupancy, that set occupancy standards. So what we do is you use a reasonable occupancy standard. And when I say that, I mean that you don't want to say only 2 people per room or per bedroom, or no more than 4 people. And the reason why is because you can run into problems dealing with families with children. When you do this, that kind of eliminates one group of people, because if you say, well, only 2 people per bedroom and a family has 4 children, well, that eliminates them right there. And you have to look at it on a case-by-case basis, because you may have a 2-bedroom apartment that's very large, and it may have a den or other areas where people can stay comfortably, as opposed to you may have a 2-bedroom apartment that's very small, and it's not large enough to house maybe 2 or 3 people. So you look at it on a case-by-case basis. And then when you're also talking about occupancy standards and what's reasonable, you don't want to talk about the sex of the children that may live in an apartment. We've had cases where real estate agents, apartment managers have put up signs that said, well, no boys and girls in the same bedroom over the age of 10. Well, this is an individual preference of the family, not for a property manager or anyone else to tell you how you can house your children. So that is something that the parents themselves have to decide, not a realtor or a real estate agent or property manager. We also talk about occupancy and housing for children. Make sure that you don't set aside units for children only, or for families with children only. We see cases sometimes where real estate property managers want to segregate children or families with children to certain areas of the building, or to the first floor, because they make less noise or they won't be walking over somebody's head. This can be discriminatory. So make sure that if you have apartments available, you make sure that the people know that these apartments are available for everybody, and you don't just select a certain group and say, okay, I'm going to show you this apartment, and I'm not going to show you this that's available. And where you see don't limit the number of children in a unit, you may tell applicants how many people you can have in a unit, but not the number of children. That would be discriminatory. We talk about familiar status. Familiar status includes people who have, or individuals who have someone living with them who is under the age of 18. And this can include parents, parents who have natural children, parents who have adopted children under the age of 18, people who are pregnant, people who are securing legal custody of anyone who has not reached the age of 18. And when you want to make sure, again, that you don't say no children. You want to make sure you talk about the number of people, not the number of children that you may have living with you. And if you talk about, even though children may make noise, you don't want to complain about, well, we don't want your children making noise. We want to just say everyone should keep noise at a certain level. Make sure you don't single out any one protected class. Disability, we at the agency see quite a bit of disability cases. And when you talk about disability, this is a mental or physical impairment which substantially limits one or more major life activity, or if someone has a record of having such an impairment, or if they are regarded as having an impairment. When we talk about major life activities, this can be just about anything, such as walking, breathing, talking, working. Those are major life activities. So if a person comes to you and says that they have some type of disability and they want to be accommodated, you have to look at it, and you look at it on a case-by-case basis, which we'll discuss a little more later. When we talk about the term handicap, and we use those terms interchangeably, handicap and disability, but it excludes people who are current users of illegal substances or drug substances. Now, if a person in an apartment is getting help, getting some type of treatment, then they would be treated as a person with a disability, but not if they are a current user of illegal substances. People have disabilities, they either, most of the time, they're going to ask for a reasonable accommodation or a reasonable modification. And a reasonable accommodation is reasonable if you determine that it's practical or feasible, if it doesn't change the basic nature of a housing, if it does not create an undue financial burden on you. This, again, is determined on a case-by-case basis. This reasonable accommodation has to be necessary for the disabled person in that apartment or condo or housing to enjoy an equal opportunity to use and enjoy the dwelling as someone who is not disabled. And we see a lot of cases where people request reasonable accommodations, and unfortunately, a lot of times people don't understand it, so they don't accommodate initially. One example is service animals. If a housing provider gets a request from someone and the person wants a service animal, most of the time, this is something that they must allow. Now, when we talk about service animals, most people initially think of a seeing eye dog. and a seeing eye dog can be a service animal. But there are lots of other animals that can be qualified as service animals. We've had cases where people have had cats because, you know, their medical provider says that this cat may have a calming effect for them and they need a cat. We've had one where people had a potbelly pig. Potbelly pig. They had it in an apartment and it was clean, and this person needed it to help their mental condition. And there were no laws in that community about, you know, those type of animals being allowed in the house, so they were allowed to have the potbelly pig and they kept it clean. So you don't just say no initially without looking at the whole situation to see why the person needs an animal and how you can provide it. Now, you wouldn't just say, okay, here, yes, you can have a dog, or, you know, sometimes people try to get around that. If there's a no pet policy and a person may have a dog, and they say, well, okay, well, this dog is a service animal, and I just need this dog because, you know, it makes me feel happy. It's not that simple. If you don't think that this, you know, person's telling the truth, you do have a right as a provider to request some type of documentation, some type of verification to show that a person really does need a service animal. Now, you don't have to dwell, you're not allowed to just to ask all types of unnecessary questions about the nature of the disability and, you know, the extent of it. But as long as you have enough information to make a reasonable determination that this person does need a service animal. And I'm going to talk about a dog because I guess it's probably one of the most common types of animals that people do request. Let's say, for example, you do have a service animal and it's a dog. Well, you cannot charge a person a pet fee for that dog. You can't make them have extra insurance for that dog. But you can make sure that the person cleans up behind the dog or whatever service animal they have. If the dog starts biting people and becomes unruly, you can require that person to make sure that the dog is under control. But you can't just say, okay, because you've got this service animal here, you're going to have extra insurance, or we're going to charge you a pet fee. You can think of a dog or any type of service animal as an extension of that person. If the person doesn't have that service animal with them, then they can't function normally as anyone without a disability. So that has to be allowed. When we talk about a reasonable modification, this is something that a person requests and should be allowed to have to make their home more livable, and so that they can enjoy the home as any person who does not have a disability does. When you talk about reasonable modification, most of the times, unless this building is federally funded, most of the time, the person who makes the request for the modification pays for it. And this modification would include altering a building or their living environment. And some examples would be widening a doorway or installing a ramp or grab bar in their dwelling. Now, when you do this, you can require the person to put money in escrow and return the building to the way it was before the person moved in. Most of the times that does not happen, because if you're widening a building or you might put a ramp, even though it's initially there for a person with a disability, people without disabilities can enjoy that also. So you don't want to, I mean, you can require it, but most of the times they keep it the way it is when they move. And with reasonable modifications, as I said earlier, the tenant pays for that modification. And I didn't talk about this earlier with accommodations, but with accommodations, sometimes that can include parking spaces. At the agency, we see lots of cases where people request a parking space. Usually it's a handicapped parking space so that they can be near their apartment complex or their condo, or, you know, and you just can't look at a person and say, well, you don't need a handicapped parking space, because you can't tell just by looking at someone whether he or she needs some type of accommodation. And I know we had a case one time where a respondent said, well, because that person wants a parking space and we had to put a sign, that's an accommodation. I mean, that's a modification, and that person will have to pay for it. Most of the cases, well, all of the cases that we've looked at across the nation have held that parking spaces are accommodations, not modifications. So even though you may have to spend a little money to put a handicap parking sign up or to paint a handicap parking sign, that's still an accommodation. And if the person requests it and you find that they need it, then it's wise to do it. And also, if a person requests an accommodation or a modification and your answer is no, well, you need to sit down with that person and explain to them why you have said no. You just can't say no and that's it. It's best if you try to work out something with the person who's asking for the accommodation or the modification, so that they will understand what your reasonings are, why it may not be feasible, or why you're just saying no. And also, if you ignore the request, that also can be discriminatory, because it's in that person's mind you have denied an accommodation. So don't just ignore it and think it'll go away. Talk with the person and try to work out something so that both parties will be happy. And when you have your rental offices or your sales offices, you want to make sure that those also are accessible to potential renters or potential buyers. And most of us who are not handicapped, we just walk in a building and we don't think about certain things that people who have disabilities may need. But you want to make sure that your office is accessible, and that can include things such as ramps for people to enter the door. To enter your building, wider doors so that if you have a wheelchair, you can enter. TTD phones. Someone may call to find out about some type of rental or housing, and you want to make sure it's accessible to them. Levers on doors. If you have a knob, people with arthritis may not be able to open that door. If you have a lever, it's easy for them to just open it and come in. Braille on the elevator buttons. There again, that's something that's very simple that we may not think about all the time, but it's necessary for other people. So, people who are blind, so they'll know where they're going. So you want to make sure that your offices are accessible so that people can enjoy whatever it is you have the office. You have to offer them. They can come in, look at houses, and they can enjoy the privileges as other people can. At our agency, when we investigate complaints, sometimes we get complaints from people who believe they have been discriminated against, people who believe that they're about to be discriminated against, and we can take those complaints. We can take complaints from anyone who has been injured, and when we say injured, that's what we mean, injured under the law. If that person believes that they have been discriminated against or they're about to be discriminated against. And the operative word here is believes that they have been discriminated against, because a lot of times when we get complaints and then we serve them on the respondents, which would be you, people will say, well, I haven't done anything. Why are they filing this complaint against me? It's a belief that a person has, and a person has a right under the law to file a complaint. It doesn't mean that you've done anything wrong. It doesn't mean that we found that you've discriminated against. It's just a belief at that stage that the person has, and that's why it's called an allegation. So, and anyone for whom housing has been made unavailable, and that can also include testers and fair housing advocacy organizations. When we talk about testers, those are people that we may send out on certain cases to see, and this is extra evidence also, but we send testers out sometimes to see if what allegedly happened to the complainant, and that's the person who files the complaint, we call them the complainant. We send them out to see if that happens to other people. For example, you may have a woman with children who goes to try to rent an apartment, and the property manager says, well, we have nothing available. And so then for some reason, the woman may feel that she's not telling the truth. Then what a tester would do, what we would do with testers, we would send someone out with no children to see, and we would try to talk to the same property manager. We would send someone out with no children to see if she gets the same answer. We would send someone out with children and see if she gets the same answer. And you do it within the same or small time frame, and try to hopefully get the same person. And those testers, we use that as evidence or as witnesses in the present case. Plus, the testers also have the right to file a complaint if they wish. So, fair housing advocacy organizations also have the right to file complaints. They can file on behalf of their clients if they believe that those people have also been discriminated against. Now, the period to file a complaint with the South Carolina Human Affairs Commission is 180 days from the date of the alleged violation. And there again, I use that term, alleged. And if a person files a complaint with HUD, the person has 1 year to file a complaint. And if a person files a complaint with the South Carolina Human Affairs Commission, and if it's over 180 days, we would waive that complaint to HUD. And what happens when a person files a complaint is, first of all, you shouldn't get nervous and upset, because again, it's a person's right to file a complaint. But if that does happen, remember that the Human Affairs Commission is neutral, and the information that we gather during the investigation is confidential. So we don't, just share that with the general public. And the respondent may respond within 10 days. And the law says that the respondent may respond. It doesn't say that they must respond, but it is our hope that when you get a complaint that you do respond. And when the investigation takes place from the very beginning to the last date of that case is closed, the investigator will try to conciliate the complaint. And the reason we try to conciliate is because it usually takes a lot less time. And then if both parties are agreeable to the conciliation, what happens is that the complainant signs it, the respondent signs the conciliation agreement, the investigator, the agency head, and it's a legal binding document. Now, throughout the investigation, I'll take you through an investigation. If a person comes to our agency and files a complaint, then once we get the complaint written so that it's in its proper form and it says what the complainant wants to say, then the complainant signs the complaint. We must have a signed complaint. Then once we get the signed complaint, we serve that complaint on the respondent. And then we request that the respondent responds. Once we get a response, and it also during this time, we also try to conciliate. And it can be a lot less expensive for a respondent to conciliate than to try to gather all the documents that we may ask for during the investigation. Say, for example, a complainant comes and says that I believe I was discriminated against because I went and tried to rent an apartment and they told me nothing was available. And I believe that they did have apartments that were available. I believe I was discriminated against because of my race. Then, we would serve that complaint on the respondent, try to conciliate. We ask them what they are seeking, and they tell us what we're seeking, and we let the respondent know. And we're required to let you know what the complainant is seeking. A lot of times they say, I want $1 million. Well, we try to let them know what is reasonable and what they would be entitled to if we were to find that discrimination occurred. And most of the times it's not $1 million. But, if they insist on $1 million, we have to let you know. So, when we do that, don't think that, it's coming from us, it's coming from the complainant. But there again, okay, let's say we have this complaint and the complainant, say, was trying to rent an apartment for $800 a month, and they believe that they were discriminated against, and so they had to go find another apartment that cost $900. And they may ask for the difference in the rent from where they were trying to rent to, between the difference between that place and where they did rent for $900. And so that's just a difference of $100. And let's assume that it took 2 months for us to investigate. Well, if we were to find cause, that would be what the person was entitled to. But if we are still investigating and they ask for this amount and the respondent agrees and they say, well, we'll give them $200 plus the difference in the travel expenses that they had, and both parties agree, then that's it, and that's the end of it. And then that person cannot file another complaint on that same issue again. But let's say that the respondent says, I haven't done anything wrong, I'm not going to settle, and you just go ahead on with the investigation, and that happens. And let's say we do investigate. Throughout the investigation, we may send a tester, and if we find that this, that they tell one group of people, that they tell black people one thing, and say whites, Hispanics, or Asians another thing, then we get enough evidence, and we may interview witnesses and see if an apartment in fact was available. And this goes back and forth, back and forth. We review the response with the complainant, and it goes back and forth until we get enough information to make a determination. And when we make a determination, it's either that we did find evidence to show that most likely than not there was discrimination, or we did not find enough evidence to show that there was discrimination. If we get evidence to show that there was not discrimination, we close the complaint, and that's the end of it. Now, a complainant may take his or her case to court at any time during an investigation, or they don't even have to come to our agency to go to court. If the person decides to go to court, then once the case begins in court, then we have to close the case. Now, if in the same investigation we were to find that there was evidence of discrimination, we would issue our finding, letting both parties know what we found. Then we would invite both sides to try to conciliate. Hopefully, they would conciliate. Most of the times they do. But if they don't conciliate, then the complainant has the right to elect either to have a hearing or for the agency to take the case to court. And most complainants would elect to have the case go to court. And then the agency is no longer neutral. Once we find that discrimination has occurred, then when the agency goes to court or takes the case to court, then we go on behalf of the complainant, we file the case in court, and even before the case is tried in court, we're still trying to conciliate through the whole process. If the case is conciliated before the court case begins, then that's good, and the case is closed, and the conciliation agreement is signed. If not, then the case goes on to court, and then the jury or the judge may find on behalf of the complainant, or they may not. And if they find on behalf of the complainant, then the complainant can get actual damages and punitive damages. And when we talk about actual damages, as I mentioned earlier, those actual damages, to use that example of a person being denied an apartment, be the difference in the price of the apartment from one place to the other. And normally we use a year, because most of the times people sign leases for a year. Also included in actual damages would be the difference. For example, if you had a job and the first apartment that you wanted was 5 miles from your job, but then you had to find an apartment that was 10 miles away, then you would get the difference between the further distance. You would also get the difference in the amount of mileage that you would have to use to go to school, if you go to school, or go to do your grocery shopping, go to church, visit your family. All of those are actual damages. Again, also, if you've been discriminated against, we find that you've been discriminated against, and because it affected you emotionally, and you went to a physician, and you had to pay a physician because you needed help, you couldn't sleep at night, whatever, those are actual damages, so you could be required to pay that, if you have receipts to show that. Those are actual. Punitive damages can be whatever a jury decides to award. And so you really don't want to get that far where you'd have to go to court, because you don't know what the court could award. We had a case last year. It was a sexual harassment case where a respondent was accused of renting to vulnerable women and then asking for sexual favors, and then he withheld the water, because the water was all connected. He was supposed to pay that. He withheld water, and he was trying to charge her extra for the water bill. And when she would not give him sexual favors, he told her she had to leave. And we tried to settle, and the complaint of the respondent would not. And once we did find that there was evidence of discrimination, we tried to settle again, and his response was take me to court. So we did, and he lost. And she was only asking for a small amount, and because of her actual damages, that's all she asked for. And she got actual damages and punitive damages. So if he'd settled, a long time ago before it got to court, then he would not have had to pay as much as he did. The court can also award civil penalties. Those penalties go back to the state. They don't come to the agency, nor do they go to the complainant. But you want to keep that in mind, that those can be awarded. And you see the amount for the first offense, if it's a pattern or practice case where we find that this not only happens to the complainant that we're investigating, we find evidence to show that this happens over and over and over, the penalty can be a lot greater than if it's just a case where it was a one-time thing. Also, we could seek a loss of licenses or an injunction from you doing business if we find that you've been discriminating against people. And also, now the injunction, now we're not talking about, well, I'll talk about that because that's there, but when we get cases where people are being evicted, or, well, yes, when they're about to be evicted, we can also seek relief from the court while the case is being investigated. What we normally do is write the magistrate and the respondent asking them to hold off on the eviction while the case is being while the case is being investigated. And when we investigate cases, we have 100 days from the date that we get the cases filed, and that's the date that it's signed. We have 100 days to try to investigate the case, so it doesn't take a long time to investigate cases. And if we find for some reason, because we have to interview more witnesses or we need more information, if we find that it is taking more than 100 days, what we would do is send a letter to the complainant and the respondent, letting them know that the case is going to take more than 100 days, and we explain the reasons why the cases are being investigated, are taking more than 100 days to investigate. If a complainant wants to file a case in court, in federal court, they have 2 years from the date of the alleged violation to do so. have questions, or if you know of someone who's been discriminated against, or if you have further questions, it's my contact information. You can feel free to give us a call, or you can email me at any time, and I'll be happy to try to assist you in whatever questions that you may have.
Appreciate you tuning in. Happy Easter. And then the questions.
Can you ask?
Can we ask Meredith?
Yeah.
Oh, okay.
Go ahead.
Yeah, if you
Sorry.
if
Oh.
you want to repeat the question too, just so you.
Oh, the question, can we ask marital status? That's not a violation to ask marital status, because marital status is not one of the protected classes in South Carolina. Classes in South Carolina. What do you mean? Can it be brought? Do you mean that while we're investigating, do we talk about it in the public?
That might.
It's complaints. Well, it's public information. While we're investigating a case, we cannot release any type of information to the public. However, under Freedom of Information Act, they can get information about a complaint once it's closed. Now, a conciliation agreement, normally those are public documents unless both parties agree to keep them confidential. Having that as a protected class in the state of South Carolina, not yet. But when we investigate cases, we have to be substantially equivalent to the HUD law. So I'm assuming, since South Carolina's law, and we're very conservative, we don't have those gays, lesbians, transgender, and there's another one, in a protected class. We would probably have to waive those cases to HUD.
More questions, feel free to email Delaine at Delaine@SCR